Fariha, you can start now.
Okay, sir, can you start?
Sure, absolutely. Thanks everybody for inviting me today in this Asia Pacific Vis Moot session on brainstorming the Vis Moot problem. It's a session which is an hour long, and what I intend to do is not completely speak for the 1 hour. That's the first thing I'm not going to do, because I would certainly invite participants to ask me questions at any point, because that's what real life advocacy is like, because you get interrupted by the judge or your opposing counsel, or sometimes you have your own client pulling on your pants and asking you to turn around to get fresh instructions. So to make this session as realistic as possible, I will try to give you my tips, but also at the same time, I'd ask that you interrupt me at any point with any questions that you may or may not have.
Sir, before we begin, I would like to introduce you to everyone, to our audience.
Sure.
Okay, thank you. Good afternoon, everyone. I, Fariha Ali Khan, on behalf of Asia Pacific Vis Moot organizing team, warmly welcome you all to today's brainstorming session on Vis Moot. What makes the first Asia Pacific Vis Moot unique is that it is one of a kind and inclusive of everyone's participation. The ideology behind this moot is to step out of the ordinary and provide an exposure for holistic development and learning. This is an exciting competition that aims to give training to young budding lawyers and students to improve their skills in advocacy and arbitration. This pre-moot will be an essential part of training for all students and arbitrators planning to attend the Vis Moot and the Vis East Moot. The skills learned here will also be a key component for future careers in arbitration. We welcome our sign language interpreter for today, which is Ms. Monica Punjabi. Welcome, ma'am. Today we have with us as the keynote speaker, Mr. Harprabdeep Singh. Sir was called to the Hong Kong bar in 2015 and practices in Alan Leong SC's chambers. Since then, he has developed a predominantly civil practice with a focus on general civil, commercial, company, and arbitration. He has appeared in all levels of court in a wide range of commercial litigation. He also regularly assists the ICLP Arbitration Center in Sri Lanka on various matters ranging from arbitration course trainings to assisting in drafting the center's rules as an arbitration expert to the US Department of Commerce. Sir, I'm sure the attendees are waiting to hear from you about this, so I won't take up much time. We welcome you, sir. The floor is yours.
Thank you very much, Ms. Khan, for that very glowing introduction. Now, in this session, as I mentioned slightly earlier, that we aim to cover the topic of brainstorming the Vis Moot problem. And what I intend to do is speak for approximately 30 to 40 minutes. And I'd certainly hope that in that period of time, or certainly thereafter, when I want to give you a short break, is that you ask me as many questions as you'd like based on anything that I've covered, or something that you think I missed or should have covered from your perspective on this session. Now, essentially, when it comes to brainstorming the Vis Moot problem, I'm going to divide it into three aspects, or three core areas. And the first one is called, how do you read the problem? And obviously, it might seem as a very simple thing to do, to read the problem. But when you're reading it as a law student, and when you certainly enter the profession, when you read it as a lawyer, it's much different from when it's been read by a layman. So when I use the designation of reading, rather than the literal interpretation, I want you to put your law student hat or your lawyer hat on and read it accordingly. So when you read the Vis Moot problem, and this is a technique that I've developed across 3 years. Well, you can certainly apply it now or modify it based on your particular context. Is usually I take the whole problem, I print it out. Now, in real life, you might have a large number of factual statements, witness statements, and pleadings. But in your case, it's just a Vis Moot problem. So I would print it out. It might be 50 pages, 60 pages, whatever it is. and I've got a preference for it to be single-sided. And then what I do is I cut out the problem into sections. I cut it out into the notice of arbitration. That's one pile. Then the second pile is the response. The third pile is the exhibits. And then the fourth pile is the clarification, questions and answers, which usually comes a couple of weeks after the problem is released. So initially you only have what I would say is 3 piles of documents. Now, what I tend to do is I read the documents sequentially. And I would immediately jot down notes using my pen with either a yellow or green highlighter as to my initial thoughts of having first read the facts. What are my immediate thoughts that come to mind? You don't have to analyze it. You don't have to disregard it, evaluate, or critique it. Just your immediate thoughts that come to mind having read that. So immediately you jot it down on those set of documents. And you do the same for all 3 categories. Then you leave it aside, right? Using your initial thoughts, start forming some sort of big picture in your mind, broadly speaking. And again, I want you to keep your analytical or critical side on one side. It's purely the immediate thoughts which come to your brain. Might be keywords, might be key ideas, might be key issues that sprung to your brain immediately, maybe even a key case. Just jot it all down. Now you can take the key thoughts you have and then put them on a separate noting pad. And as I said earlier, I divide mine into sections. So what you could is take all your highlighted notes and put them neatly on a separate notepad, highlighting your initial thoughts, divided into sections. Now you could do the same once the clarification comes out too, in 2 to 3 weeks afterwards. Now that's step 1, which is what I do when I take any new case. And step 2 is you build a chronology. And again, we're still within the first section of the analysis called reading. We haven't really jumped in yet. So the first kind of subcategory of reading is what I call reading the facts, dropping it into sections. And then step 2 would be, well, make the chronology. Now, chronology, and I was told this by a senior many years ago when I did a case, if you don't do your own chronology, then you have to use the other side's chronology. So you might as well do your own. And there is always value to a chronology. Now, you might think that a chronology serves either a singular or dual purpose, but actually it serves a multifaceted purpose. And I'll explain to you how. Now, the way I do chronologies is slightly different from how other people might do it. So again, this is more of a personal perspective on reading the Vis problem. Now, when I make my chronology, I do it in 2 strands. I lay out in terms of facts vertically. So if you've got a big table, what I would do is I would vertically lay out all the facts from, say, A to Z, with no times, no dates, just the facts. So say, for example, fact 1, John was walking on the street. Fact 2, Alice has an apple, so on and so forth. Right? So I would purely lay out the facts which I can glean from the notice of arbitration, the response. And so I give you an example would be, is that the claimant has appointed so-and-so as their lawyer, right? Fact 1. Now this would be one chronology based on the sequential order of documents from page 1 to page 50 or whatever it is, right? So I would lay it down, vertically speaking, on my table. Now you could handwrite it and type it out. I mean, I'm not going to get that nitty gritty, whatever works for you. What I would do is immediately underneath that chronology, I would make another chronology perpendicular to the first one. And that would only have the time and the dates for each factual event. So again, going back by the first example, if the first fact is that the claimant appointed, say for example, Mr. Rajesh Sharma as their lawyer, that would be the fact on top as part of the first chronology. And as my perpendicular chronology underneath, it would have the date, 29th June 2020. The reason why I separate these two particular events is that it allows you to analyze the facts and the dates separately. Now, we all have the ability to some extent to look at visual representations, but according to human psychology, the eyes are more receptive to pictures than words. And so the more words there are, the harder it is for the brain to process because there's too much information. So what you do is when you dissect the information, you make it more easily noticeable, you make it more digestible, and you make it the trends and the patterns more visible. So when you have these factual assertions on the top end and the timeline at the bottom, the timeline will give you a certain pattern on its own. The facts will give you a timeline pattern of their own. And then when you look at the two patterns together, they will give you a whole new pattern. And using this approach, you get to see that the chronology aids not only in you understanding the particular factual circumstances as to what the party did, it lets you understand as to the relevance of the timing of the events. And then when put together, it will be useful for your case. Because as with the Vis problem every year, it's got two types of issues, one procedural and one substantive. And both of them heavily rely on timelines because it requires the parties to discuss when a particular challenge was made, how it was made on the basis of certain information available or not, was it done within the requisite period, so on and so forth. So instead of having to move quickly through 50, 60 pages, which is not easily understandable, that chronology, if properly done, analyzed, and referred to, will make your job much more faster. And the patterns will become much more clearer. So as you go and progress in the case, whether it be writing a memoranda, whether it be coming and progressing to the oral arguments, that chronology would be your building block foundation to analyze the Vis Moot problem. Now that's the first step of called reading the problem. Now the second thing, once you've done the chronology, is you should have by then an understanding of the parties. What is the matter going on? What are the key facts in dispute? What are the key players in this particular arbitration? What are the key exhibits? And what are the key factual assertions which will be repeated again and again, whether it be for the procedural issues and the substantive issues? Now, again, as I mentioned, if your chronology is done effectively, these patterns would easily be discernible. You would see the repetition of certain names again and again. You would see certain times being referenced in different documents again and again. And so that would lead you to a pattern where you would be able to understand that certain documents hold more value evidentially than others. And what this does, and will lead me to the third step, is that that would affect the quality of your arguments, because you're able to then discern as to there's being two types of facts. One being primary facts, facts which are key, significant, detrimental to the case, and secondary facts. Facts which would aid your case if these facts were in your side, but even if they were not completely on your side because they are open to interpretation, are open to various arguments that if you were to prevail on them would make your case rock solid, but it wouldn't kill or be a rock out punch on your case. And so that gives you the ability to bifurcate those two sets of facts. Now, this will take obviously a certain number of weeks because it is not exactly a science. The legal field is an art. So to make the chronology, to discern the patterns, to understand the significance of the facts, to understand which facts are more important, this is a process of several weeks. Now, but once you've done it, what you would do is you will aid your progress as you move on to the phases of memorandum writing and oral arguments. Now, having done this, if you are able to discern these key facts, then a trick that I do for all my cases ever since I joined the profession and ever since I've been practicing since 2015 is I sit with my entire legal team. Now, there might be 4 of you or 3 of you or 2 of you, however many, to the best of your abilities, we sit all together and we read out the facts very slowly, word for word, line by line. You will be mesmerized as to the difference between reading the words quickly and on your own to reading the words slowly, individually, and then category 3 to reading the words slowly, but as a group. So what usually happens when I prepare for trial is I would read the witness statements of the other side with my team of solicitors and other lawyers, and we'd sit together. We would go through each word line by line, and one person would read out the words and the others would listen. Now, the listeners are not exactly sitting around and doing nothing. They've got a pen and a notepad. Whoever's speaking, they would immediately jot down their interpretation of that sentence without speaking to each other. And at the end of each sentence, we would all compare what is our collective interpretation of that particular sentence. And the benefit of such a reading is that even within your own team, you're able to get multiple interpretations on the same document. Yes, Vaibhav, I saw a hand go up. Is there a question? Well, I'll keep going forward. If there happens to be a question, please do either send a text or indicate through unmuting yourself if you wish to ask the question. Please feel free to do so. As I was mentioning, when you're able to sit in the room and read each sentence line by line, you're able to discern a pattern because everybody processes the information differently. So you're able to understand the different interpretations, even within your own team, as to the merits of not only the evidence, but the interpretation of such evidence. And the next step is, after you've done this, is that you collectively take your notes and you evaluate the interpretations as to, number one, do most of you have the same interpretation? That would lend credence to the majority view as being the most likely interpretation by other teams, whether it be in the moot or in others, in real life, whether it be the arbitrators or the judges. And that's the first thing. If you've got multiple interpretations, that would lead you during the memorandum phase to put your hats together and say, right, this document is controversial. So when you are evaluating each of these documents and witness statements, right, the more different interpretation that document has, that means that document is problematic. Now, when I say problematic, it doesn't mean problematic in the sense you're not able to deal with it. It is that it is a document which requires attention because you've got 3, 4, 2, however number there are in your team who are not able to agree as to the exact interpretation of that document. And so that particular document should then be given more attention in terms of reading, research, case law, looking at various authorities in line with that particular document to see why is it so difficult to agree on the basis of that document. Now, again, I contextualize it by saying it is impossible to discern it immediately because this is a collective process. So you might be able to do this before the memo phase. And I suggest you do this again while you're doing the memo, after the memo phase, and before you begin your oral arguments. Now, when you're doing your oral arguments, whether as a team in a simulated arbitration, or whether you're doing it in practice rounds against other teams, pay close attention to the controversial documents or the controversial aspects of your interpretation, because those are the things you should watch out for. Again, this entire process of you, as I said, brainstorming the Vis Moot problem should be like a filter funnel. So a filter funnel, as you see, is very broad at the top. It's like a pyramid. So it's like this. So the top end is broad because it allows you to collect all the facts, the patterns, the case law, right? And so you should keep a broad mind. So when you start, it should be really broad like this, which is why I told you, pen down your immediate thoughts and highlights immediately without thinking too much. Collect as much information as possible. Just let it all in, facts, law, any form of initial views. And as you progress, it should be like the funnel in which it is sieving through, and so it's becoming narrower as you get along. And so that analysis, the patterns, the research, the interpretations, it is now narrowing your views on the case and allowing you to understand which positions are more appropriate than others in terms of arguments, in terms of patterns, in terms of facts and law. But those are the 2 stages you've gotten to so far. If done properly, with the chronology, with the research, with the interpretation, sitting in a room, analyzing these facts, and you fast forward this process by 2, 2.5, possibly even 3 months, your end product would be a distilled, refined set of anticipated and expected arguments. And that's the terminology I'm trying to use. So expected arguments are arguments that you can expect most teams, if not all, to make, because the pattern's too easy to not miss, too discernible, the arguments are too clear, the arguments are crisp, that no party could miss it. Now, those ones are which you'll hear all the parties make. And so that doesn't make you stand out as a team. The arguments that you should work on using all these skills are the anticipated arguments, the ones that only the arbitrators would expect because they've got the practitioner experience by looking at this problem. And so those are the ones you should focus on building. And they only come after you've worked on it for a significant period of time. And so those are the ones which makes the teams excellent. The anticipated arguments, the ones which are not always formulated, not always expected, and certainly not always well executed. Those are the ones that the teams, if they do make, are the ones which get the memorandum awards, the best oralist awards, the awards concerning arguments which were not A, expected, and B, not always anticipated, and C, even if they were anticipated, were so well executed that they were flawless. And those are the ones which tip the balance in the favors of the teams either prevailing or coming up first or second runner-up. Now, if you were able to do all these things in terms of brainstorming, step 1 and step 2, or as I said, reading, that will take you to the second step of what I would call crafting your arguments. Now, obviously, crafting would come in 2 forms. One is the memorandum phase in which you're writing the claimants and respondents memorandum, and one is the oral arguments. Now, everybody's got a different style because I've seen many styles both during my Vis Moot period and after I've entered the profession, and even in different countries, right? My style is what's called a flowchart style. So assuming that filter funnel that you've employed, which I've discussed earlier, has worked. You've collected all this information, you've distilled it. Now, if it is correct and the process has worked, and this is a reverse way of checking whether the process has worked, each year in the Vis Moot problem, there's 4 issues, 2 procedural and 2 substantive. If the process has worked, all your arguments should be able to fit on one A4 size paper, one-sided. I know some of you are quite cheeky, you're going to say double-sided. No, it's going to be one-sided. So if the process has worked, you can condense, distill, and consolidate all the arguments of 60 pages into 4 A4 sized one-sided papers. So 2 pages for procedural, front and back if you choose, or if it's single-sided, 2 pages, and then substantively, again, 2 pages. So your entire 15-minute argument orally should be based on those 4 pages. And if you roughly account about 2, maximum 2.5 minutes per page to speak uninterrupted, that should give you 8 to 10 minutes of oral arguments, leaving about 4 to 5 minutes, depending on whether you have a rebuttal or sub-rebuttal, for Q&A, interruptions from the bench, for you to pause and think. You need to have some buffer time. Now, that process, when employed, if you bring it down to 1 page, can come in many different forms. The way I do it, it's called a flowchart style. Quasi-flowchart, quasi-bubbles. What I do is I put the central argument right there in the middle of the page, and then I branch out into 3 branches. So hypothetically speaking, let's say the first procedural issue had 4 main arguments to make, right? So you would have the central building block, which is your first procedural issue, and it would have 4 branches coming out at each edge of the block, okay? And I would draw this on 1 A4 size paper. On each branch, I would put a bubble as to what that argument is. So that bubble would contain a few words to highlight me that key argument. Each bubble would also have 3 branches coming out. And those 3 branches, number 1 would be fact, number 2 would be law, and number 3 would be policy. And that is what me and my fellow participants learned from my coach, Professor Rajesh Sharma, which I've also employed in my profession, which has been nicknamed the 1, 2, 3 approach. So in quickly re-summarizing in a slightly faster way, you've got your main argument, you've got 4 arguments, and each argument should have 3 branches: fact, law, policy. And remember, always in that order: facts, law, policy. Now, some people might think otherwise, but I'm of the firm belief that not just most cases, all cases are won on the facts. regardless of however strong the law and policy might be in your favor, if the facts are not in your favor, you will not win. Whether it be in terms of the oral arguments at the moot, and whether it be in real life. And when I say win, in terms of winning, not the moot in terms of the competition, but winning the analysis, the critique, the evaluation of the arguments. So when you're analyzing the arguments, remember, facts are supreme. So do not put the cart before the horse. Do not force the law to fit the facts. Do not bend the law, right? You'll end up coming up with an extremely bad argument. The facts should lead you to the law, not vice versa. You shouldn't think, right, this argument sounds like it's law X. So let me pick law X, and then let me try to force the facts into it. That's wrong. You should look at the facts, see what legal principles emanate from it, and then try to research the law. That is how you would be able to find particular sets of law which may aid in your argument. And remember, even if the law is weak, that is fine, because as I mentioned, facts are supreme. At the end of the day, the tribunals are looking at whether you can build a tough argument on facts which might be in your favor, but the law doesn't favor it. A prime example would be, for example, if you are conducting an arbitration in which another party has purposely created the conflict by bringing in a lawyer or a counsel at the last minute into an arbitration hearing who happens to share a personal relationship with one of the arbitrators. Now, the other side might feel that this is a conflict and would like to have that particular lawyer leave the arbitration or not participate. But the unfortunate circumstance is that there is no power in the rules empowering the tribunal or the other side to raise an objection that their counsel should be removed. So in this particular circumstances, the facts are on your side because it's undisputed that he is there and that he has a personal relationship. But unfortunately, the law does not aid you because there is a lack of legal provision. So what you shouldn't do is try to create some kind of conflict of interest under a different category just because it's more established, like under the orange, green, or red list of the IBA rules on conflict of interests, just because it's easier to prove, but it doesn't match the factual circumstance. So when you're doing your arguments, right, remember fact, law, and policy. Now, what might happen is that when you're doing this particular A4 size arguments, and I said there's a bubble on each with 3 prongs, I have not prioritized them. This is a continuing evolutionary process, right? Now, it's taken me a lot of time and a number of years to distill it to 1 page. You might not be able to do that immediately. So I do appreciate that it might take you a bit more time. So it might take you 2 pages or 3 pages. But whatever the process is, and you can take my word for it, it can all be distilled to 1 page eventually. And this is especially true for the Vis Moot, right? So no matter how complex the issue, no matter how distilled the argument, it can always be boiled down to 1 page on fact, law, policy. So when you've got these particular arguments, you have to then, after having made them, prioritize them in terms of strongest to weakest. When you're doing your arguments, whether it be in the memorandum or in the oral phase, human psychology dictates that the attention span of human beings is very low. You've got about 30 to a maximum of 60 seconds in the beginning to set a good impression. And that applies to reading and speaking. So when you're doing your written memorandum and your oral arguments, remember to focus on your strongest argument first. Now, you would see from the Vis Moot problem that the procedural issues have already been identified, and so have the substantive ones. So that would at least take away one issue for you to decide, which is how to structure the arguments, because they've already been dictated in the problem. But what you need to do is then determine the strength of the arguments as to which one goes first, and so on and so forth. Now, if you were to employ this filter funnel /1 for a four-sided paper, which is also known as the 1, 2, 3 approach, you would find that your process of writing the memo is far more easier, quicker, and efficient. The number of hours you need to spend to get this done is also going to be far more significant. But that is why I said that it's better you spend the time now and get it done now, because later on during the memorandum or oral stage phases, you would find out that the process is a lot more faster and easier because you've done all the heavy lifting in the beginning. Now, some of you might be thinking, all right, I've distilled the facts, I've done the 1, 2, 3, I'm still not able to understand which one is stronger and which one is weaker. And you've employed all the methods of sitting in the room, reading it out. All of you disagree in the interpretation. Research is not particularly helpful. Then the litmus test, which is what I use to determine whether or not a particular argument should go first, second, or third, is look at the case backwards. Do not start from the front end, because it's sometimes known as walking with, a deer in headlights situation. So what that means when you say looking at the case backwards is look at the issues and ask yourself, if you were in the tribunal and you had to determine and write a written decision on these particular issues, what did you need to prove to win the case for either the claimant or the respondent? So sit back and look at the issues and think to yourself, what are the elements of this particular argument that need to be argued? Number one. Number two, what are the factual circumstances that need to be shown to win that particular argument? And number three, if that particular argument is won, do the other particular arguments matter? And that goes back to my earlier point on fact, law, policy within each branch. If the facts are so substantially in your favor, does it matter that the law and the policy are weak? And then reverse it. If the law and policy are strong, does it matter that the facts are weak? So when you look at the case backwards, think of it as an arbitrator. If you had to write the award, how would you write it? And attempt writing it. So before you go down the track of finalizing your oral arguments or starting to write your memoranda, write it from the reverse. So start by saying the claimant has won procedurally and substantively, and for the following reasons. Because of A, the facts XYZ were in their favor. B, the law XYZ was on their side. And C, if there is a policy reason, look at the policy and see who it favors. Now, when I say write it out, it doesn't have to be in a 40, 50 page written award, but you need to physically handwrite or type out this decision. When you type it out, as I said, type it out as an arbitrator, thinking cap as a judge on, to see what would that decision look like if this was the correct decision? If you are unable to write that decision on behalf of the claimant or respondent, the areas which you get stuck at, also known as writer's block, is the part you need to focus on in order to win the case for that particular side. So if you're writing the award, say, for example, on the procedural issue for the respondent, and you're writing it saying that the respondent wins, but as you're writing it, you're unable to justify the decision on the law, either because there's very little law, or the law that you have, whether it be case law, rules, provisions, books, anything you have, isn't strong enough to justify the conclusion, then you know that that is your weak point. That the law on the respondent's procedural issue is problematic for you, then what you need to do is go back to the beginning of this lecture and go back and start your filter funnel all over again. Because something has gone wrong. As I said, if the filter funnel is applied correctly and done efficiently and properly, the only facts that remain and the only law that is discernible is the one which aids on your case. So if you put aside the chronology perpendicularly, you've read out the words, you've done the flow chart and the bubbles we discussed, and that's taken place across several weeks and or months, you're only left with the discerned facts. There's very little for you to hide from because it all comes down to one single page. But if looking at that page, you cannot write a decision, that means at somewhere across the process, you have either missed something, incorrectly evaluated something, you've attached more weight to a particular piece of fact or law that is actually incorrect, or you're looking at the whole fact or law wrongly. And therefore, you need to start the process all over again. That doesn't mean entirely for the whole case, but for that particular argument. So when you write the closing for your whole case, whether it be on procedural or substantive, the more holes you have, the more, well, to put it bluntly, the more number of times you need to go back and start all over again. Now, the filter funnel, as I discussed, it's a long, cumbersome process, correct? From here to here. When you're writing the award and you're able to understand that there was a minor problem here, you don't have to start it from the beginning, but you need to go and identify where did that problem first occur. It might not have been when you were making the chronology. It might not have been when you were reading it out in the room, but it might have been that you picked another member's interpretation which just doesn't match. So you've now got to go back to your notes and look at, were there other interpretations that you as a team came together to see whether those other interpretations work? So you've got to identify the glitch as to when it occurred, right? If you can remedy it from that period. If you can't, then unfortunately, my only solution for you is to go back and start all over again and redo your chronology because something has gone wrong. If you're not able to write a reasoned award, and when I say reasoned, I mean fact, law, policy on each particular point, which would justify the main building block. So if you've got this block and you've got 4 arguments and you're saying one's enough to win the case, then that one argument must be airtight. It must be so strong that it's not subject to any other minor arguments. And if you need 2 arguments to win, then both of them need to be equally strong. If it's 3, then 3. If it's 4, it's 4. And as the process goes on, you're able to understand, right? So the strength of this entire filter funnel to end process is that it makes you understand when writing and arguing which arguments to focus on first in terms of priority, which ones are more factually relevant, which ones are more legally relevant, and which ones you're able to speak for 8 minutes, which ones you're able to speak for 6 minutes, which ones you will attract more questions on the law, and which ones you need to be aware of have multiple interpretations. Now, I see that we've got only about 10 minutes left in this session. So before we end, now I've got a question from Alpesh, and he's asking, what do you actually mean by policy? And that's an interesting question. Now, sometimes you've got policy which comes out from law, and that's called legal policy. And so all of you will be aware that the arbitrations applies the New York Convention. And so you've got policy in terms of international public policy and national public policy. And that's an analysis of certain jurisdictions' cases and their position within the arbitration regime. That's one version of policy. Another policy is to discuss, for example, floodgate arguments, in the sense, does this particular argument, although factually strong in this particular case, does it set a bad trend in arbitration that would hamper the progression of arbitration as a whole moving forward? So usually it's known as the weakest of arguments in each branch. And it is used most of the time when the facts and the law tend to be against you and it's not completely favorable. Then parties rely on policy arguments, whether it be under a particular statute or whether it be in terms of floodgate arguments to argue that certain trends, although allowable, should be avoided to stop setting a bad trend. There's another follow-up question from Alpesh, and his question is, our approach in framing arguments should lead from issues given, or we should filter out the arguments at the end? That's an interesting question, and I've seen both versions being applied. Now, in my experience, you should do the former rather than the latter, which is you should frame arguments based on the issues, rather than you should filter out arguments at the end, because that would save you time. And again, I say this with a pinch of salt by saying that if your filter funnel has worked, then your issues should be rock solid. There is no reason for you to doubt the issues that you've picked out. And as I said, if you've got this big filter funnel, yeah, and it's collected all the facts and all the law, you've left nothing out. Anything that remains in the filter funnel tube is the discerned issues, right? You've got the moot problem, you've got the clarifications, you've watched all these videos on the problem, you've watched these seminars, you have heard every single interpretation, every single viewpoint, you've heard and looked at all the research. You should be able to discern what the issues are, if it's done correctly. Having done it correctly, you've got no reason to doubt the issues, and you should frame the arguments on the basis of the issues. Now, as I said, if you've got reason to doubt your arguments, write the ending for that issue as if you're an arbitrator. If you've got your particular issues with your subset arguments of fact, law, policy, you should be able to decide the issue with no problem whatsoever. Now, if the arguments you have, fact, law, and policy, and you're struggling to write the decision for that particular issue, whether it be because the facts are weak, or you don't think the law is strong enough to support the facts, or you think the law is weak, that means either you've made a mistake as to that being an issue, or your arguments are weak because you haven't done research, or you don't look at the facts in a way which show the analysis of the issue, or at some point, there is a chance you have misframed the issue. And misframing can come in many ways. It doesn't necessarily mean you've got the issue wrong. It might be that you're looking at it wrongly. And that requires, again, to go back, whether it be at the beginning, whether it be in the middle, or whether it just be you go back and look at it as a team to see whether or not you've actually made any mistakes. Now, if you've gone through the entire process and you don't see any mistakes, then what you are dealing with is an argument which is novel, or an issue which is quite recent, and therefore there is very little legal authority. That is where policy becomes very important. So when you're dealing with novel issues, as I discussed earlier in this session, the removal of counsel, which is quite recent in the past 3 to 4 years, there will not be a lot of cases, and the facts will certainly not be out there in terms of broad discussions. So you will then have to rely on policy arguments and on the little case law you have to frame the arguments to decide the issue. Most rules currently do not provide the power to the tribunals to remove a counsel expressly. So the corollary is, if you are relying on a policy argument, then think of it from the perspective of, does the tribunal have the inherent power as a matter of fairness? And again, fairness is not something that you would see as an express rule in the Arbitration Act of the country or in the arbitration rules. It is a quality embodied as a principle of arbitration, i.e. fairness. So that is where policy comes into play. So again, the issues and the arguments interplay with each other, but I think the arguments flow from the issues rather than vice versa. And it's the same way that I would invite you to be drawn to the law after having analyzed the facts, and not pick the law to try to force the facts to fit into it because you think the law is easy to argue because it's got a lot of case law and good authorities for you to analyze. So facts, law, and policy in that sequential order. If you do it the reverse, you risk upending the issue or forcing the facts to fit the issue, and then you would bleed questions either in Q&A at the oral phase, or your memorandum wouldn't make sense as a matter of arguments because it would seem force-fed by putting the cart before the horse. I think that summarizes the essence of what I wanted to say. Before I go, I'd like to share a book which I thought was one of the best books I've read so far in my career. And I don't know if you could see it. It's called The Greatest Salesman in the World. It's written by O.G. Mandino. And it's a very short book. It's roughly about 100 pages or so. And I'm not going to spoil it for you, but it contains some very eloquent lessons on advocacy, on how to approach the ability to sell. Now, obviously, we're all lawyers, and when we sell, what we sell is arguments, but that's no different from the general idea of salesmanship. So if you've got time and you've got the ability to access the book, again, it's called The Greatest Salesman in the World by O.G. Mandino. I would certainly advise you get a copy from the library and read it, because it will teach you the basic skills of selling, which is not any different from advocacy, because you're selling arguments, not as a form of monetary relief, but selling them to try to persuade the tribunal. And you can certainly learn from the book the ideas in terms of thought and collaboration and research, which will give you the general skills that you could apply in brainstorming the Vis Moot problem. There's about 2 minutes left. If any of you got questions, I'm more than happy to take them, whether you wish to read them through the chat room or you wish to unmute yourself, you're more than welcome to do so. But if not, yes, please.
So we have a question. The question is, during the making of memorandum, if we are to form an argument for the applicant, then how do we form an enough justification to oppose the same for the respondent?
So what you would do is, again, go back to what I said in the beginning of this lecture. When you've got the filter funnel, when you look at the facts and you look at the timeline, you don't look at it from the perspective of applicant and respondent. You look at it neutrally. And as you go through the funnel, and when you look at the facts and the timeline, you would see, when looking at the documents, this document aids the applicant, this document aids the respondent. This particular fact and this particular date is good for the applicant because it's within time. And this particular date, in fact, is not useful for us because it shows that we were too late in doing this. So when you're looking at the facts, Don't break them down. Look at them neutrally and mark them down as you progress through the phases of the filter funnel to see which one aids which side. And therefore, when you make your arguments, you would already have them in your hand as you're drafting the memorandum. So I hope that answers that question. Is there any other follow-up questions, Fariha?
So there is another question, not a follow-up for this one. While forming an argument out of an issue, what should we focus on more, the fact or the law? If they are not in our favor, the fact or the law?
Definitely the facts, always the facts. Facts are supreme because at the end of the day, the arbitral tribunals are always open to interpreting the law because they have discretion most of the time, unless the provision is set in stone. So they're able to interpret it in a different way. What they cannot reinterpret, which they will refuse to reinterpret and they will never bend, is the facts. So when there is a conflict between the facts and the law, facts will always be supreme and they would be the ones which decide the issue. So if there is a conflict between the two of them, I'd always advocate on the supremacy of arguing the facts. Any other follow-up questions for you?
No, sir, that's it.
Okay. Well, I think that covers my period for today, unless there's anything else I can assist in further.
If there are no further questions, sir, with your permission, we would now like to conclude the session.
Okay, thank you very much. I hope the session was productive. Thank you so much for Ms. Punjabi for doing the interpretation. I know it must not have been easy. I wish you all the best and hopefully I'll see all of you very soon in the future pleadings.
Sir, it was an honor for us to have you present with us today. Thank you so much for taking out time in your busy schedule for us. We look forward to our future webinars and are extremely excited for the first Asia Pacific Vis Moot. Till then, I hope everybody across this forum keeps safe. Have a good evening, everybody. With that, we shall now be ending the meeting. Have a good evening.
Okay. Thank you. Take care.